So let's get going here. First step is the approval of the agenda, and again, I have some there for those who may not have it. But just simply the first reading reviews M1, 10, CO2, M04, and adjourn. So any our committee, any changes, disagreements, whatever, I'll consider unanimously approved. Public comments, that's anybody. Public comments from anybody. Okay. As we start our first reading reviews, I'm going to ask Frank if he would make a few comments as basically the originator of it, of the package, as to what's involved here in these resolution actions trying to be accomplished, that sort of thing. Frank, if you would, please.
Let me explain what I'm trying to accomplish and why. First, we had a work group that looked at violations of the declarations of restrictions, okay? Which at this point in time, the way that we enforce it, I think it would be safe to say has totally frustrated the Architectural Review Committee, probably similarly frustrated the CPI department and board. And the specific reason that I brought this whole issue up, which started with should we fine people that violate the declaration of restrictions, was a homeowner coming to the board and pleading for help. And she basically said, this is the thing that I wake up to, the mess I wake up to and look at every day for years. And I was thinking, okay, if we have violations of our declarations of restrictions that have gone on for years, okay, neither the board of directors nor the management is doing their job. So we either have poor boards, poor management, poor processes, one of the three or all three or two of the three. So that's what triggered the work group. And we looked at it, and basically, when it comes down to it, to just give you a scope of what we're looking at, the Architectural Review Committee, or the CPI department more accurately, gets up to 12 complaints a day. The vast majority of those complaints are handled within 30 days.
Frank, I'm sorry to interrupt. Is there one overreach or overarching architectural review committee? Because I've been told we have a separate one over the point.
You know, I think what can happen is this, and this is now not in my wheelhouse, this is you guys' wheelhouses. As Ocean Pines has developed, we have at least 22 different declarations of restrictions. And I think there might even be more because some of the sections have subsections. Okay, and as they developed over time, and no section is, I want to say, not that no two sections are alike. There can be a lot of differences within the sections. Mm-hmm. For example, one of the things that we found out was that sections post 1995, generally the board of directors can implement a fining policy with a vote of 4 people. Generally.
A fining policy.
Right. Okay. Pre-1995, no. There are some sections right now that don't that, for example, one of our current hot topic, some sections like the park don't permit short-term rentals, period. Mm-hmm. Other sections do. Sections that Jeff lives in, you're permitted to have a fence in front of your house. Most of Ocean Pines required
to have a fence in front of your house.
Most sections you're not allowed to. So you get differences of the declaration of restrictions. And as we dug into it more and got into these violations and looked at the number coming in and the number resolved, the vast majority are resolved within 30 days. So, but those that aren't resolved within 30 days, you go into a process of, okay, the board does certain things. We ask attorneys to do certain things like write letters, and they go on. Some of those have gone back as far as 14 years.
Mm-hmm.
Yeah.
Okay? So you look at it and you say, what's wrong? And quite frankly, there are people in the media that basically say, well, you're not using the tools that you have. And I look at the tools and I sat there at a board meeting and I see, okay, now it's time for the board to spring into action 14 weeks after the original complaint. We're dealing with a complaint right now that the original complaint goes back off and on to 2005. And it's, okay, so how do you force fast, quick compliance of declaration of restrictions, given that that's the legal contract to maintain your property, okay? And given that your homeowners, fellow homeowners are complaining that, you're running a junkyard next door. That was the whole trigger thing. So we looked at it, and the conclusion that we came to, which is certainly open to debate, is the most egregious ones. And that percentage, by the way, is 17 cases sent over to our attorney, which is 0.002% of the homes in Ocean Pines. They just flat out wouldn't give a rat's rear end about fines.
Over what period of time? 17 cases over what period of time?
It's currently there. Now, some of those go back again for a long period of time,
Gotcha,
okay?
Gotcha.
So,
I've read a couple that originated in 2014. I haven't seen the ones back to, but I was amazed that it was 2014.
so you look at it, and the difference of opinion is, quite frankly, our counsel has said if you implement fines, at least you keep that within the association. We've looked at it and said the most egregious ones would just ignore the fines and continue to go on. So again, we looked at, well, why do some of these drag on? Okay, and it's a combination, in some cases, process, and a combination of some cases, implementation of the tools that we have. And, just in another case, just we can do it faster if we want to. I mean, I guess that's what it boils down to. So to give you the 3 examples that led to the specific thing of changing these resolutions, in one case, 3 years ago, there was a property that had a blue tarp on the roof, weeds up to your thigh. Its property, I think, is number 4 Bramblewood. And one of the people running for election, happened to be director at that time, Slobodan Trendic, who was elected, said this is a big deal. Well, today that house is still not occupied. And if you drive by it, it still is kind of so-so if you wanted to live next to it. So you ask the question, well, how does this happen? And it turns out that in that case, the heirs predeceased the owners. So we were following our procedures, sending, in effect, dead people.
And they
And dead people.
back.
And dead people don't respond. Okay? Another case, property again had gone on for years. The individual that complained to the board, it was just a case of people that had owned a property for a long period of time. They turned it over to their children. There's absolutely no reason to believe they're in any financial distress. They just have a lifestyle that would detract from the properties around them and don't comply with the declaration of restrictions. Now, in that case, because of publicity, because of pressure from the GM, one case where I will say the board voted to go on the property to clean it up, the property has been brought up to where people are at least accepting, okay? The third case, and the poster child, is number 8 Willett Way, where they've gone through the process, off and on since 2005, where they refused to comply, where we went to court and got a court order to instructing them to clean up their mess, and they are currently in the process of violating the court order. And in that particular case, a person in the media called and said, you might want to check out this property. And I looked and I had something when I was first elected, and it was like, well, this has to be cleaned up because we have a court order. So the issue was having an untagged vehicle in a driveway. So, and I told the board kind of, half-heartedly, it was a case where both I was correct and the media was correct, because I drove their property and looked at it. They did not have one untagged car in a driveway. They had 2 with an active court order. So that just kind of drove me to the edge and said, look, if we're going to do this, then, and there's some also discussion with other members of the board, let's go on a 30-day and out process. You have the violation, you have 30 days to clean it up or show substantial completion toward cleaning it up, or we're going to court to force you to do it. And that's what all those changes are designed to do.
And then if, Frank, just for my own interest, so if there is non-compliance with the court order in 30 days, would we continue to do and file contempt?
Yes, and that led to a second discussion as to, if you're not aware, but I suspect you guys are deep enough into them to understand this preeminently. The way our declaration of restrictions are worded right now, in a number of sections, which was in the board packet, we cannot collect attorney's fees for legal action.
It says that specifically?
No, the wording is missing, and because the wording is missing,
Okay.
and then the opinion of the council, which is, if you don't have the board packet I give you, which is under apparently the American rule of law,
By omission.
if it's not there, you can't do it. However, in a case where we have a court order and we go for contempt of court, we can ask then the judge to award the fees for us, the legal fees to us, because they're in contempt of court. And, to put things in perspective for the committee, one of the side issues of it was, well, what's the cost of this? Our current counsel, which I am obligated to listen to as a board member, gave me a range up to $50,000 to get a court order, up to 6 months, and an average range between $12,000 and $18,000. Which immediately some folks, again, predominantly in the media, said, that's not true, that's BS. So we talked, when we use a local attorney, in fact, the local attorneys can do that less because they don't travel from Montgomery County, they travel from Ocean City or Ocean Pines down to Snow Hill. But nobody has said, we'll never hit the upper limits. Depending on how much fight the violator has, whether you go through depositions, whether you go through discovery, you could run up a big legal bill. So just kind of for the record, we asked, what is it going to cost us to go in and enforce the court order that we already have at 8 Willow Way? And the estimate came back $10,000.
I'd love to see the breakdown on that. I should have charged that.
And that, by the way, is with a local counsel. So the documents that you have in front of you are just exactly that. What I tried to go through and what I said, and I still am. I mean, the question came up, one question. Do we write an entirely new resolution or do we amend one? I really just don't care. Whatever's easier, whatever makes more sense for the way things have been done in the past and precedent. What I want is the 30 days and out kind of situation. And all the changes relate to that, with the exception of one. And I think that's the one that is in C02, about the board voting to go on and remove rubbish. And here's what I'd say about that. The reason that I put that in there is Public Works, CPI department, Public Works, the police department, and our legal counsel have a deep aversion to the board sending somebody on property with the vote of directors in the current societal situation. For two reasons. You run into, if somebody has McDonald's wrappers and leaves, you can clean that up. But if you have used plumbing fixtures, a washing machine sitting out there, a grill that's half assembled, there's kind of a just general one man's trash is another man's treasure, so you have to go to court anyway. And the second thing is we don't want any kind of confrontation, be it verbal or violent. So even when the board voted to go onto the property, which was 54 Bramblewood, the police said, get a court order to back that up. So what we're saying is no need for the board to go and vote to go onto a property, because if you don't clean it up in 30 days, we're going to go to the court. And the court advantage of having a court order when they send somebody to enforce it, that individual has 3 tools that we don't have to enforce our DRs. They carry a badge, a gun, and a warrant.
So with regard to the contempt issue, so the contempt case is won, then what is the enforcement mechanism?
It's entirely out of our hands.
Well, may I, Frank?
Yeah.
When I have filed contempt for failure to follow a court order, whether it's a family law case, a civil case, whatever it is, the judge will usually give in his or her decision a span of time in which you have to come into compliance with that. And will give generally an admonition, I better not see you back here again, and sort of hopefully put the fear of God into people. Now, if we have contempt and they do not comply, one of the remedies that the court can render is a bench warrant for the arrest of the person who's out of compliance with the court order. That's a little bit down the road, and I know that's a real, do we really want to do that? But it is a remedy that's available.
So that's where I was going with this question. So let's say they, just like they don't comply with the original court order, they don't comply with the contempt. So is that another process for us to go to the courts to get the bench warrant, or is it some sort of natural process?
Depending on what the infraction is, no, a court is not going to issue a bench warrant without action by the party complaining.
So then we're going back to court again?
There's another factoid in this thing. If we go back a couple of general managers, we had a general manager here who strongly believed that you do not kick a person when they're down. And the board would vote, and the action would go to the general manager's office, and you would hit a brick wall, and he would not enforce it. And I talked to him about it at length. It's something, he has a very strong belief that if you're experiencing any kind of difficulty, financial or otherwise, and you live here and you can't pay to clean up or whatever, he would not enforce. It didn't matter what the board said. Board said, we're gonna send out somebody and shoot him. Yeah, I mean, he wouldn't enforce it, period. And that was the reason. And that was always the reason. And if you challenged him on it, he would take it and simply not enforce it again.
So that brings up a good point. Assuming we can get a hold of the owners, let's say the property is occupied.
Mm-hmm.
Do we have a process whereby the GM or somebody sits down with them, talks through it with them, maybe finds out that maybe it's a single mom with little kids, she can't afford to pay somebody to go remove the washing machine, whatever, and then there's a process by which we can say, look, we can have somebody come out and clean up the front yard, cut the grass. If you're okay with that, you give us permission to do that, we'll come out, we'll make the front of the house look presentable, to the street, to move this along. Do we have something in place like that? For people who are cooperative?
The answer is yes and no.
Sort of.
Yeah. We do have a process like that in place. That's why so many of them are
That's the
cleaned up,
ones.
okay?
Gotcha.
And in the case of when we started working on it, to give you kind of one insight, there was a fence that was erected on somebody else's property, and that went back to 2005. And John went out and talked with them, okay? And it turned out that it wasn't the entire fence, but it was a portion of the fence, I guess where it intersects, came onto the property line, and it was apparently constructed, if I have the facts, remember facts correctly, constructed before the person bought the property. Okay, so it went back that far. And it had been a long-running dispute. And what the person agreed to do, just based on talking with John, is move that section of the fence. Now, there was another thing that it didn't comply with the setbacks. Okay, but the agreement was if you move the section that's on a person's property, then until the fence is replaced, you don't have to comply with the setbacks. So yes, there's
Reasonable.
people can talk through. However, here's the other thing, and this is where in one of the reasons in writing those the way I did, you can't really legislate common sense, okay? And when I say that, kind of the perception is that these distressed properties belong to somebody that bought a house here when Ocean Pines was first opened. They've long outlived their income. They're on death's doorstep. and spending the money to correct something, it means you don't put food on the table or you don't put medicine in the medicine cabinet. And the truth of the situation is, in the egregious violators, we simply haven't seen that. Okay? So now, not saying we haven't seen that in egregious violators, I would hope, okay, that if somebody did fit that model and the CPI department went, that the general manager would tell the public works department to go clean up the property and then forget about it. And I would hope that the board would agree with it, and that when it got out into the public, into the media, that they would agree with it. Okay? I think I might be hoping for too much in all three cases. But certainly right now, I feel fairly confident that if that situation came before the board, that we would tell the people to go clean it up free of charge. And I feel fairly confident that certain media would explode with protest. But because we're a homeowners association, not a charitable organization, in their point of view, which is a valid point of view. But like I say, you can't legislate compassion and common sense. You just hope that they exist in the organization.
Yeah, and you have to watch for the alternate agenda running, because referring to the general manager that I was talking about, he gave all the appearances of supporting the action to send somebody out and clean it up and bill them and whatever. And when it got in his office, brick wall, he would not do it.
Just a suggestion,
Period.
the idea of
You couldn't make him.
sending public works out to clean it up. One way to mitigate that might be just to ask for volunteers from the community, because I know there's people, like on my street, people that need help. We just help each other, right? And you could probably get enough volunteers to form a little group, so that when things like this came up and the homeowner was amenable to it, that this group or members thereof would go there and do the work. That way you keep public works out of it. It doesn't become an Ocean Pines business function. It just becomes a community, neighbor function, neighbors helping neighbors kind of thing. But maybe that would be less controversial, but I'd be willing to bet you could get plenty of people to volunteer for such a thing.
Yeah,
I'd be
I
willing
would
to
think
do
you
it.
would. But,
Yeah.
Again, I think for most, I don't know, I've lived here since 2013. Most years, things have been reasonably financially stable enough that if Public Works went and spent $1,500 or $2,000 cleaning up a property, no big deal. I mean, especially today, because the association's doing extremely well financially. When it's losing $1.2 million, people might have an axe to grind with doing that. But, again, common sense and compassion. And it points out, even with this, there's two things in there that I'd point out when you really, at least as I've been forced to think about it over time. The general manager really at the end of 30 days doesn't have the option. It's go get the court order, okay? And compared to the past, we've made no attempt to say, here's a minor violation and here's a major violation. You're either in compliance or you're not. And again, it's on the premise that you hope that common sense reigns.
Yeah, but it doesn't always.
It doesn't always, and who knows, 2-3 boards down the road, 2-3 years down the road, somebody may want to go get a court order for somebody's grass being 3 inches instead of 2.5 inches. But I don't know how you can control that reasonably.
Jeff, were these cases, excuse me, just for my own clarification, are these cases going to district court in the landlord-tenant days? I don't know if they have them in Worcester County. We have them in Hartford County.
They are supposed to.
Okay.
They don't very often. We have gotten involved in court cases a couple of times, but it is not done, at least to my knowledge, it's not done on a routine, regular basis. Like, this is the next step, you just do it.
Okay.
We don't seem to approach it that way. And one thing to be careful of, this don't kick them while they're down attitude is not held by one person. there are a number of people around here who believe stuff like that. Not everybody, but they don't think that it's fundamentally right or fair to take somebody who's having some kind of hardship, medical, financial, whatever, and impose on them more expensive duties that are at some point going to cost them cash, whether we do it and bill them or they do it themselves and pay for it. It's going to cost them cash, and that's the part that the don't kick 'em people don't like. They don't think that's fair. They don't think that's right. And if you talk to them, they'll come up with whatever reasons are fueling their belief. And they're not always the same, but those reasons are always there. And in my experience talking with people over time, they really believe that is the right thing to do. And the association is in a much better position to just suck it up and take care of it.
Okay, guys, I want to kind of get us into the review of the
Okay.
resolutions. The first reading reviews, before we get too far off on go from the specific to the general philosophical kind of thing. All right, first up is resolution M01, and that's to rescind the resolution. And I think Frank in his description of compressing the time frame and also what I'll call a firm stop in the context of court order, court action, is the distinction between the existing, or a major, if not the sole distinction between M01 and M10. And I don't know that I don't have any further comment than that. It's just simply replacement of one current operating procedure with another one. And the review of M10 will be more important than simply talking about whether we should rescind M01.
I looked at it, and I mean, if you just redline M01 and take M010 and look at it, the replacement is fairly good.
Yeah,
It covers most of the issues. I mean, there are a couple questions we have with it, but
yeah, I would suggest if there's a good reason, or not good, a reason for changing the number, I would prefer that we simply replace the current M01 with M10. And I don't see any procedural problem with that. We can, however it could be phrased, I would prefer we retain M01.
I have absolutely no problem at all with that.
Okay.
okay.
I don't have anything further on that first reading. How about the rest of the committee here?
Right.
All right, let's
Okay.
move on to M10. I guess what I would like to do is just start at the top of the resolution and work our way through. If any of the rest of the guys have any other approach, be fine with me. One first comment I want to make and kind of get it out of the way, excuse me. I think it's perfectly appropriate that this be, at some point in time, go to the attorney for review. Now, what kind of a review, when in particular, at some point in its consideration by the board or after the board approves some version of M10, it goes to the attorney. That's not our call, if I can put it that way. In the past, going back 10 years to when the current book of resolutions was developed and resolutions were reviewed and new resolutions adopted, the practice was that the attorney actually signed each and every resolution. That was cut out with the beginning of this current book of resolutions. And if you look at B01, it's a recommendation. It kind of implies it's a recommendation from this committee, but it can be recommendation from a board member, the general manager, staff, whatever, public comments for that matter. But I do believe that this is one that should have an attorney review. When and what part in time that be done, that's not our call. I'm gonna step a little bit out of line on my next comment and stop here for a few minutes. There was Frank, you mentioned a work group, and very infrequently do we ever hear anything out of the general manager or staff regarding resolutions in which there is some action of the staff. And I would hope that somewhere along the line, the general manager and or his staff, or the same thing, have reviewed this document, this proposed resolution, and made any appropriate comments. That's, again, I consider myself stepping a little out of line when I make that comment, because it's your board, your general manager, and you can do with what you want. But that's, I would hope that we have general manager involved in what this has in it.
I would say yes, by virtue of the work group. First, this package went to both the Architectural Review Committee and the work group before it went to the board.
Mhm.
And the only comment coming back officially at the board meeting was the Architectural Review Committee fully supports it.
Yeah.
Okay, as by the way, now I can say, I also 100% believe that the CPI group and the general manager fully support it also. But they didn't make that comment at the board meeting. But at the board meeting,
Yeah.
that was that the Architectural Review Committee is fully
I
on board with
understand,
it, okay? And again, they would have, because I do 100% agree at some point, how we do it procedurally, I'm not sure of. We'd send it to the attorney to make sure that we didn't do anything that would be,
Okay, that's my first comments. I'm going to turn to the rest of the committee. Down to 4, I don't have any comments. We get to 4 is when I have some comments. Let's pick up at 4. Does anybody have any comments they want to make on starting at 4?
I'm sorry, can I back up just real quick to 3 Bravo? The intent of the board that the GMM compliance permitting an inspection hereafter referred to as CPI staff focus on these violations that present a health or safety risk, comma, and or compromise the appearance of the surrounding neighborhood, comma, thereby detracting from other people's property values. It seems like one of those definitions that is everything. What would the alternative to that be? It doesn't seem like a helpful definition, in other words. And maybe I'm just being nitpicky, but when I read that, to me, in my mind, I just translate to everything. So safety or health and or something that makes a place look ugly and makes my property value go down. So
As opposed to being in the interest of public safety?
I'll interject a little bit. It is a degree of rewrite of what is in the existing M01.
okay, so this is existing language.
It's similar to, in
Okay.
fact, extreme.
Okay,
A sentence or two verbatim. It's a shortened version of what's already in M01. I think it's the right way to say that.
okay.
It's
I was around at
basically
the time
the
this M01 was initiated, and there's
let me find it
a
here.
fair amount of philosophy in it, if I can put it that way.
A lot of
And
these-
the intention
Worded that way.
of the
Yeah.
current M01 was to focus on, I'll use the word egregious violations. And that 3, I guess it's what is it, 3B? Yeah, 3B kind of carries that forward, the same words.
Just, in my mind, I'm replaying some of the things that were said earlier about, 3-inch grass versus 4-inch grass, and I don't know, from a standpoint of having to go to court, make an argument, that says this is compromising the appearance of the neighborhood such that it's detracting from my property values. Is later on in this document, does it get a little bit more specific or no? Or is there just a level of discretion here that's assumed?
It's like I say, you can't legislate comments. Now, off the record as much as you can be with the media here and being recorded, right? Okay. I would hope, okay? And with two attorneys present, okay? I'm not an attorney. My job is to raise them and pay for their way through law school. I would hope that if we went to any court in the state of Maryland and we said, we want a court order because this person's grass is 3 inches high instead of 2.5 inches, that the judge would say, I want to talk with you privately in my chambers. And in those chambers, the judge would talk with our attorney and give him a message that would be largely unprintable in the media or on tape. Because that would be such a stupid, egregious waste of legal resources and court time that the court should probably find us in contempt of court.
So I agree with you. I agree with what you're saying. I'll just offer this. In the event that this comes back and somebody is looking for something more specific, there's actually terminology used by the insurance industry for homeowners insurance, property insurance, liability cases that apply to trip hazards, that apply to, it's, if somebody wanted to put more in here, we could probably pretty easily come up with some language. It's pretty much industry standard for liability on a property, either to the owner itself, to somebody visiting the property, that sort of thing. So I'll just leave it at
Well,
that.
and if I may, another kind of overriding concern is bear in mind that 99% plus of the people, okay, comply. And really, if you talk with the CPI guys and the ARC, it's like, gee, I didn't know I was in violation. I'm gonna straighten it out, okay? When you get down to this 0.002%, you have people that understand the rules maybe better than any single board member does who gamed the system. For example, on 8 Willow Way, okay, there's a standing bet. Those cars will disappear, okay? They will appear in some driveway 4 blocks away, 5 streets away, different section of Ocean Pines, okay, that's unoccupied, for sale, seasonal owner. CPI will be called, cars are removed, sign off on the violation, and then they appear back. Now, why would I ever say something that demeaning? Because it's happened since 2005, okay? The fact that we have a court order and we have the same violation shows, and that's the mindset that exists that you're trying to combat. And as a result of that, one of the results of the gamesmanship of this very small percentage is no differentiation between a minor and major violation as has occurred in the past.
Got it. Okay.
In other words, look, we're targeting the people that are trying to game the system.
Right.
I'm with you.
I think it has to be, I don't think that there is an exacting standard. I don't think anybody's gonna take a ruler out there and measure the grass.
No.
But what it seems to me is that a reasonable person would find that infraction is a threat to public safety. It demeans the appearance, that you and me, as reasonable people, would go and say, yeah, that's bad.
No, I agree. And especially what we're talking about here is you're only going to be making this argument in these egregious cases where probably it's very obvious what the concern is.
Agreed.
Well, the other thing that quite frankly puzzles me, and you can probably clear it up for me, the courts that I'm used to watching work, when they issue a court order, you bloody well better follow it. And about all you have to do is whisper in the judge's ear that so-and-so is not following his order, and on their own, they went after them with a vengeance. Violate one of my orders, will you? You didn't have to go make a case about violation. All you really had to do was say, Fred isn't doing what you told him to do. He's just not complying. And the court took it over, and I don't know if Worcester County does that. It does it that way.
I haven't tried those cases in Worcester County yet, to be perfectly frank.
Okay.
Okay, I'm going to interject one quick comment,
Okay.
kind of for the record. When it comes to tall weeds and grass, there are dimensional criteria in the DRs for whatever reason. It's split into two segments similar to the fining provision. The earlier provisions, I think it's 10 inches, the later sections, 1995 and later, I think it's 6 inches. But there is for grass purposes, there is a tall weeds and grass dimensional criteria in the DRs. That's, I know, not particularly relevant, but I thought I'd
But interesting.
enter into the record, so to speak. Okay, moving right along on this. Are we down through 3? Let's put it that way, ready to go on 4.
Okay.
Okay, Bob?
Yeah.
Kevin? Anything on 4?
I have a question on 4D1, and shouldn't declaration of restrictions somehow be in there to be consistent with the violation? Because it's identifying, I think it would be helpful if it said something about declaration of restrictions.
It is 4?
I'm not sure that's the way place it belongs, but 4D1.
Okay, Bob, I'm having a little trouble understanding. What is your concern again?
On 4D1,
Yeah.
it says show review violations of DRs. Okay, I missed it, you're right. It's there, I'm done. I withdraw my comment. Okay. I get too far into the weeds.
Are they at least 10 inches?
Okay, so I have no,
They're at least 10 inches high.
yeah, so to speak.
Okay, I'm gonna start my comment
It's right in front
on
of me.
this part. My concern is making sure we are clear in our authorities, in particular with regard to the GM and with regard to ARC. For example, you'll find in various places in this draft, as well as when we get to C02, that's the ARC committee resolution. You see a reference to in D1, 4D1, where Bob was further on. The ARC committee gives the member the opportunity to be heard at the next meeting, and if deemed appropriate, forward the violation to the GM for further action. And you go further back in this, I'll go back to, I believe it's 6C, I believe, or 7Z, I'm sorry, 7Z. It starts out, the ARC determines the violation should be, if the ARC determines the violation should be pursued. And then further down the very last sentence of that provision, you have alleged violation. And if you go, again, I'll just skip ahead here briefly just for adding it all together to C02. I'm gonna miss this, okay, here it is. 4E of C02, and this is the duties of the ARC committee shall include reviewing possible violations of declarations and restrictions identified with the Department of Compliance permitting an inspection, and when appropriate, referring the violation to the general manager. We're mixing things up here. I think we need to make sure that we clarify the authority of the ARC committee. Does the ARC committee can have at least three elements to its consideration. One would be the just giving the member an opportunity to be heard, to challenge, to whatever, call it due process if you want to. The second is to make sure that the member has the opportunity to know what things can be done, waiver or variance if it's possible, initiate a necessary permit process, and in particular, it is made mention in M10, perhaps effectively negotiate steps that can be taken and can be accepted as a work plan to get it done. And now, does that include, or what is the further authority of ARC? Does ARC have the authority to say this is not a violation, go away? I don't mean that literally, that's poor choice of words. This is not a violation, can't be enforced, we're not gonna send it to the GM. Does ARC have that authority? And is ARC the final authority? When it gets to GM as a violation, is it in fact true that the GM has no choice but to proceed on a legal action track? I don't see that to be clear to me. I'm gonna be qualified. I don't see that to be clear in M10. And then I don't see that to be necessarily M10. I think that can also be said about M01. It's never really been clear what the authority of ARC is. At any rate, I have a concern that we have not got clear description of authority within the draft resolution. And I look in particular at the if appropriate language that's used there.
Yeah. You can drive a truck through that.
Yeah, you can.
And I think that, well, it is in C-02. I don't recall in my 2 or 3 recent readings of M10 whether it has the same language in it or not. But it's in M10, and of course it's in the C-02.
So Jim, what you're asking for is a chain of communication, and where in that chain there's authority to take definitive action?
Well, let me try to rephrase it a little bit. I believe it was in public comments, and I don't want to try to identify the individual because I may be wrong, where a comment was made to the effect of not agreeing with or not thinking it appropriate for the board to not be the party that authorizes going to the attorney, going to court, literally, let's put it that way. It's improper or should not be considered proper to delegate that authority to the general manager. Well, really, are you not delegating that authority to the ARC committee? If they can go from ARC and the general manager not have anything that he or she can say about it. And I think you can read that into M10. And you can also easily read into M10 that ARC can say, "This is nothing wrong with this. We're not gonna pass it to the general manager."
I believe ARC has those powers,
Aren't
in
the
my
ARC,
opinion right now.
aren't the ARC decisions non-appealable?
Only for my opinion, only for property permits like construction permits in particular. I think that's the way you read the DRs. It's an overextension to say a violation of the DRs. This is my long-held view, and I could be wrong. I certainly agree with it. The violations activity of ARC is a delegation from the board to ARC. It is not the assumption of governing document authority by ARC.
Okay.
That's always been my view. I think ARC's non-appealable decision process or decision action circumstance is limited to where a property permit is required. In particular, the most basic would be building a new home where there's no home. Or, no home on the lot at the present time, which of course is not very many probably, or any exterior modification to the property. Not a violation of the declarations or the ARC guidelines. But
That would actually make some sense. because you wouldn't, if you take some of those things that are currently not appealable and make them appealable, you'll never, ever get to a resolution of almost anything. There'll always be a fight about something like that, and at some point, you have to say, I have a process that's fair enough, due process, whatever, and their decision stands, that's it.
But who has that? I mean, I think what Jim is saying is, does the general manager act on behalf of the board, or is it the board by votes, decision-making about what happens to that issue? Or is it the architectural review committee?
Is so the intent of what I'm doing, just intent, is not to change anything for the first 30 days. Not to put any additional rules or anything, any changes in there. So my take on it, and the way I tried to do in putting this out, okay, which is I think maybe the first time I've tried something this comprehensive, is not to empower ARC to do anything more or not to take anything away from what they do currently today. Okay, so what process they have for that first 30 days, I'm perfectly fine with. It's at the end of the 30 days, okay, when we go through what I call our kind of merry-go-round slow dance is what I want stopped. It's like, if you don't, through the existing mechanisms today that are defined, if at the end of that 30-day period, you have not corrected the violation, which is CPI signing off on it, or you haven't given them a work plan that they're satisfied with, okay, the GM goes to court. And really, even to that point, no flex, not, and you know, Jeff was very polite, I'll be somewhat less politically correct. I don't want another Thompson situation where we go, the CPI and ARC goes to him 3 times and he says no, and you have a demoralized staff and committee. I want a situation where he goes, and if he doesn't go, he's answerable to the board for not doing his job.
So,
That was the frustrating part.
Yes. It was made quite clear to me. And that's, so up to that point, no changes. And after that point, the changes, and again, just my thing, but it could be wrong, is the board is now empowering the GM to do this, delegating this responsibility to the GM. And if you don't do what we delegate to you, then you're answerable to the board. Now, you know, who knows what board, what GM and what board will cause, what GM will not enforce it and what the board will do at that time. Who knows?
Okay. I don't have any problem with the process for the first 30 days either. But well, I know what I would do if I was the GM and faced with a situation where I had something come to me that I said, this can't go. You know, I wouldn't flat out do nothing. I'd come to the board and I said, look, here's the reasons why this won't fly. And,
Right.
And
I think that is a process to trigger a dialogue, a more a further investigation, and come to the right answer. I don't have any problem at all with that. I didn't like the secret brick wall, where in public or in meetings, very supportive, you know, right thing to do, charging off, and then you get inside the door of his office and nothing, I mean nothing, happened with some of these things.
Okay.
And if you queried him on it, you get all kinds of weird answers.
okay, once we get past where we are now, and hopefully that can be done fairly quickly, we're going to get into definitions, in particular definition of violation and secondarily of complaint. But when you reach a violation point, whether that decision is at the CPI level, which almost has to be to me, but I'll hold that till later. once you have established something as a violation, whomever, whether it's CPI, affirmed or confirmed by the art committee, and it goes to the general manager, he has to act on that in accordance with obtaining legal action, court order, however you want to phrase it. Whether we have court order as the term used may or may not be appropriate, I'll leave that up to the association council. But at any rate, the question in particular is the authority of ARC. Can ARC literally say, this goes no further? Because
Or this must
it
go
must
further.
go further, yeah. It's binary, or it could be binary.
Jim, not to throw a wrench in the works, but I have been charged with Colette Horn. We are working on, we did not realize that there was no current job description for the general manager. And we are working on tightening that up. So I am in process of writing drafts for the general manager, and I know that in one section, taking it from what had existed before was the buck stopped with the general manager under the authority of the board. This wasn't a discussion in his job description about the architectural review committee per se, but it did certainly give credence to the fact that the general manager is working under the direction of the board and is empowered to make those decisions on, under that authority.
Okay, well,
So what you're basically pointing out is that you feel that there's a gray area that there potentially is an opportunity to address with this language.
yeah, I really don't want to try to prolong it any further. I certainly am not looking to write words to put in a resolution. It's just that I see in here, at a minimum, language that needs to be cleaned up. Alleged violation has no part in here. That's a very minor
We
thing.
can scratch that out,
But-
yeah.
But you have the if deemed appropriate is a troublesome language for me.
Scratch that out too.
Very troublesome.
And I just kind of want to leave it with that so that we're not, we have time limitations, at least Kevin does.
As the author, I would say, anything like that, feel free to scratch out. I mean, just scratch it out. And I would just say, to your point, as a board member, this is my understanding. If as a homeowner, I have a violation and I go to the architectural review committee in one of their biweekly meetings and they grant me a variance, or if they said, in fact, upon further review, that's not a violation, that process dies right there.
That's fine with me.
That's my understanding of how it operates. So, which I think answers your question. The fact that it is binary to them. It is either violation, or we deem it for whatever reason not to be a violation, or tertiary. We'll grant you a variance even though it is a violation. But that seems to be another different set of resolutions that we would have to clean up.
Okay, well, I'm not gonna say. I have a little bit of variance from that way things are done, especially if I was a member of management, but let's keep on going.
We're talking about a decision that has a couple of different parts. And those parts can be assigned different places logically. You have the policy, if you will, the policy-based decision about what it is needs to be done. There's a violation, needs to be fixed. And then you have the execution arm, bad term, that says, I am now gonna take this decision, which I didn't make, but I'm going to execute what it takes to effect that decision because it was made by the proper authority. And maybe what we need is some language that clarifies the fact that they are the proper authority. And I, the general manager, have a part to play in this process, but it's a different part. I don't get a vote on this necessarily. I get to go make it work. And there's some logic around the fact that that's what general managers do. Okay, is they take the decisions made by the board, upper management, take your pick, and then they have to effectuate that decision and make it actually happen on the ground, day to day. And they're two different activities. They're not the same.
I agree with that.
I agree with that.
Okay, I'm in basic agreement. My concern is that everybody knows who's got what authority.
Right.
Including the authority to say, at the ARC level, including to say this is a violation. I recognize that the GM's responsibility, he is designated as the individual under whose authority the compliance program is to be administered. Okay, ARC role is to pass or fail something as a violation, or it says that they're deemed appropriate.
Mm.
What else is appropriate? In particular, what else is appropriate other than a move to legal action? I'm not gonna proceed any further, except I'm in agreement with what you.
Well, and what deemed usually means is, I'm going to make a decision without work. Okay, I'm not going to work to figure out what the actual answer is. I'm going to deem the answer to be this, based on whatever, but I'm not basing it on work. I might, I suppose, but I don't have to. And I think if we're clear that those are separate, number one, I think they can be separate. In fact, I think most times they probably are separate. You rarely, at least in my experience, you really have the enforcers and the deciders the same people. They have different skills, different outlooks, and different perspectives. And they're just not the same.
Okay,
If I may interject, I don't want to drag this on too much longer, but it sounds to me, the way I interpret the language is currently in this draft. It essentially says we got to keep a record of all the complaints that come in. CPI has to do that.
Yep.
And then it doesn't say specifically, directly, but the insinuation that I read into this is that the GM is responsible for monitoring that record. So if the ARC looks at a complaint, gets logged in, and they look at it and they say, that's not something that meets the definition of what we would enforce. It's still been documented, correct? And the GM still sees it, correct?
I'm not sure about seeing.
Well, he's seen the fact that it's been documented, right? We received a complaint from Mrs. Smith that Bob's grass was an inch too tall.
Yeah.
Our committee, our ARC determined not actionable. The GM sees that and would have an opportunity to go back to ARC and say, I disagree with you. We got to get them to cut the grass.
Well, why would they do that instead of going to Colby Phillips first?
No, I'm just saying with regard to process and to address his concern, all the complaints get documented, they all get logged.
Right.
And the GM has, from what I'm reading in here, has some level of responsibility for monitoring what's in that log.
Right.
And the actions taken or not.
Right.
Well, that's
Okay.
something we have to look at, because a lot of these documents don't understand what an operations director is. We didn't have one.
Mm.
Okay, we did not have a director of operations. It was all the GM.
Oh, that was why you brought up Colby. Okay,
Right.
I get that point, but I guess to his concern, my point was, I think what's in here is injecting the GM into the process of oversight of the actions. So if Colby takes action, if the ARC says action necessary, Colby takes action, the GM's still seeing all this, right? The GM still has an opportunity to inject themselves into it.
It's a standing agenda item on their departmental meetings.
Right.
And what I would say is, this could be a leap of faith if you've lived here a long time. If the board is doing its job, if the GM is not exactly on top of all that, okay, the board should be ready to ask the question, why aren't you?
Right.
So John right now may not be, he may have delegated that to Colby, may have delegated it down to Eddie Wells. But I can tell you that from what they told me, there's records going back forever on homes that have violation. Whether he looks at it or not, I don't know. But if that record's not kept, if that record's not available, he should be asking a question. If he's not, the board should be asking him why you're not doing your job.
I think, to me, that's what's important is the record.
I do too.
I think that's the important part, because whether or not the ARC has the authority to say it's actionable, it's not actionable, all of that I think gets worked out in the wash as long as it's documented. If they they didn't document it because they didn't think it was actionable, so now there's no record of the complaint ever occurring in the first place, I think that would be problematic.
Absolutely. If you don't look at, if somebody doesn't look at and review records, it's only a matter of time until they're garbage.
Yes.
And if they're there at all. So having the general manager look at it is fine. I don't know that he necessarily should do anything, but I think he damn well should look at these things.
It's just all part of his or her oversight.
That's right.
Right.
And if he sees a pattern of stuff that looks weird, then he needs to talk to Colby or Eddie or whoever and say, explain this to me.
Right.
And
There's a trend here that's strange. That's
Well,
out of that comes an answer that says, yeah, it's great, I just didn't understand it, or no, that's a dumb thing because you didn't understand it. And the only way you get that is to have the dialogue.
somewhat reassuring in this process to give you, specifically for one of their properties, okay? I think it was Cammie asked the question, how long has this been going on? And it was Friday afternoon, okay? And the response came back within minutes, off and on since 2005, okay? And the response from the general manager was, wow. So here's what that tells me, okay? In the board communications, John, okay, because he's copied on it, obviously looked, obviously asked CPI. They obviously had the record. They responded back within a matter of minutes.
It was.
Okay? And so that process in the inner gears of the association is working. Now, could I attest to exactly how it's working? Not a chance. Okay, but it's there.
Well, and if it shows up somewhere in annual reports or summary records so that other people are looking at it too, it's really odd how that helps other folks get it done. Because if I'm charged with doing it and you're gonna ask me and I go, duh, I don't look very good. And when my performance review comes up, somebody might say not paying attention or whatever. So there are consequences, in some cases really bad consequences, to not looking, not asking. You don't have to dive down to the bottom of the rivets, but you gotta look at this stuff and see. I mean, I had managers managing big contracts. I trusted them. Bet your life I looked. Because we were talking massive amounts of money. And that was part of my job, was at the end of the day, to be able to stand up in front of Intel senior management and say, yeah, we did the right thing. And I don't know it because Fred told me. I know it because I looked. And they were ornery enough to ask that. So.
Okay, before we get too far into internal operations that are not really part of the resolution, I want to try to wrap up my comments and find out whether or not I got consensus among the committee members. My basic comment is I think that the resolution should be reviewed to assure that the relative authorities are clear with regard to, in particular with regard to the art committee and the general manager. I'm briefly looking at something else here. in 6C, it says, the titles of the subparagraphs, member notification, and that part of it at least is talking about what goes out to the member. And it goes on to say, informing the member that the violation is not corrected or substantial progress toward correcting the violation is not underway within 30 days, that the matter will be referred to the GM to obtain a court order to force compliance. What's in the, again, this is kind of nitpicking, but that's in the notifications going out. Say that the general manager will go for legal action I think would be, assuming that's the correct understanding of his authority, I think it probably is, not have it part of the member notification. And I'm going to get ahead of myself, and I don't like to do this kind of editing of somebody else's work. But I think 6C, the member notification paragraph, would be better structured, and rather than one multi-sentence, multi-line narrative broken down into steps, and maybe even a C and a D, which is the member notification, and D, general manager's responsibility. Getting ahead of
No, I
myself.
see what you're saying,
Yeah.
yeah,
But anyway,
I agree with that.
do I?
It's all mixed up into one big paragraph.
We generally don't take votes on stuff for those of you who are not ordinarily here, and that's not just during my tenure, that's historically. We get a consensus, everybody says, sounds good to me. A comment that we believe that the authorities of the art committee and the general manager should be looked at and perhaps clarified or more
Defined,
detailed expressed. Is that
I agree with that.
Yeah.
acceptable for you
I agree
guys?
with that.
Yes,
Yeah.
All right.
I agree.
And before we move quickly along here in this resolution, what I will be doing as soon as I can get this all together, and I know Frank, you're here, of course, I will be getting out an email report of our comments individually to Frank, to the board of directors, and the board of directors' email address. I'm also in communications with Lisa Schwartz. I will put her on that address list as well, since she was invited to attend and was not able to, nor anybody else on the committee apparently. All right. I think we're down to definitions. Any comments on the definitions?
I have one question before you go there. I'm missing something, but we got 6 general procedures, and then we dropped down to 8, but I can't find 7.
Okay, I missed that myself.
I mean, I noticed
And I
it.
see that you are correct.
No,
Good catch.
and I tried to look to see if I was missing a page when I
I
copied
think
it.
8 should be numbered 7.
That should be number 7, okay.
Okay. All right, I'm not gonna note that in the report.
But on number 7, I do have one comment for you all to consider. I
Which
think
number
that-
7?
The new number 7.
The new number 7?
Just
Okay.
Number 8.
Gotcha.
I believe there should be another sentence or something added there. Because the intent is not to change anything really, like I say, except for getting this court order. After 30 days mandatory, there's an issue of the board then being requested by the GM to find the violator in continuing violation. And that, the purpose that it should be in there, and I believe the reason it should be in there is that deals with their access to our amenities and taking away certain privileges.
Okay, well, that means you're gonna, the new 7 or old 8, the GM will notify the board via email when action is taken and will include a summary of actions in their monthly report to the board. You're gonna have the agenda item on the board, at the
Right.
next board meeting.
Right, but it would be not to get the court order, which would already be in process. It would be to find them in continuing violation.
Okay, I understand that.
Oh, I see. Okay.
Yeah.
Yeah,
Okay.
that makes sense.
Uh,
I have on definitions, paragraph 5, when we're ready.
Okay, go ahead.
Okay, so as I read through 5 definitions, 2 things. We basically have 2 parties involved, right? We've got the responsible party, which in here we call the OPA member, and then in B we say financial or non-ownership entity. And then we have the complainant, whoever's bringing the problem to our attention. And then down there we use slightly different language where we say that it could be from inspection reports by CPI inspectors, persons, or reports by association members or residents, telephone calls, email. We don't use the same language throughout.
We should.
We have to standardize this language. So I recommend we add to the definitions maybe a responsible party, and the responsible party would be OPA members as defined by in a subparagraph, financial non-ownership as defined by subparagraph. And then we use the term responsible party throughout the rest of the discussion when we're talking about who we're going to take to court, who's going to court. And then we do the same thing for complainant, who can bring forward a complaint. And, that may be, and so we add that as a definition, the inspectors, members, residents, because residents means people who are renting, right?
Sure.
Yeah.
Because we don't define it in here, so I'm just assuming that. But we wouldn't hold a renter, we wouldn't take a renter to court over property.
No, it would be the owner.
Right. So I think there's just some consistency with what we call people, how we define it, what we refer to them as, that needs to be cleaned up in the definition.
Yeah, every time, in my experience, every time you use different terminology, somebody is
Oh,
going to
yeah.
ask why.
You're just
And
leaving
what's
yourself
the
open
difference?
to problems. Absolutely. Yeah. Especially if the end result of this is somebody's going to court, then it should be a little bit more clear and specific about.
It really should.
Absolutely. Look, couldn't agree more.
Yeah. And then there's one other. So my recommendation is to add 2 new definitions. One definition would be responsible party. And then maybe we could subparagraph A and B under responsible party. And then the second definition would be the complainant.
Yeah.
And then under that, we describe anybody and everybody who could bring forth a complaint. And then we use those 2 terms throughout the rest of the discussion when we're talking about who we're holding responsible and who we're essentially responding to or taking inputs from.
Yeah.
And then what is it? 5G. Somewhere in here, there's just a word missing.
In 5G itself, I have a comment that a violation of the DRs or guidelines exists. I think it would best be may exist. It's not going to a violation until presumably a CPI goes out and says, yes, this is a violation.
Well, yeah, and I think there's some more wordsmithing could be done because it says by association in-person reports by association members, but then it goes on to list all the different possibilities of non-in-person reports. So there's just sort of redundant. It could just be the in-person could be removed. Just reports by association members or residents, either by either in-person telephone, email, US mail, whatever. But somewhere here, there's a word missing. I could have sworn I wrote it down.
Well, there is one on the top of the next page.
Oh, maybe that's what it is.
At least
No, you're right. It is in
the next page, top of the next page.
entering onto a for
Yes.
such. Yes.
When
So it's in B. It's the rollover of B.
All right.
Yeah. Yeah. 6B.
Okay, I want to make sure that I get this comment down correctly. Because among other things, I'm searching.
Well, you recorded it, right? So.
When are you going to have it?
Could you get a transcript of that?
No.
No.
Okay, well, I have the part, we wanted to define responsible party, and then we have, complainant, how and who and how it's made. To revisit those or add to those definitions. Is that sufficient detail for me to put in this report?
I would-
Well,
I
to
would think so.
standardize the usage of such terms throughout.
Okay, I heard that and didn't.
Because if you wrote it and you understand what you're talking about, it all makes perfect sense. But if you're coming at this fresh and you're just reading it verbatim,
Yeah,
it starts to get, it could get confusing because different terms are used in different paragraphs, but they're really intended for the same purpose and under the same circumstance.
I think that's one of the areas over the years that we've been a little short in verbiage is definitions.
Right.
And I think some people look at it and say, well, it's just, common use of the word. And the answer is, I don't necessarily want that.
It always has to be written for people who aren't in the room.
Right,
Because everybody in the room knows what you're talking about.
right.
This is a procedural.
This way you
this
can
is
never edit your own work.
Procedural
That's right.
question to you as the committee. Okay, I'm 100% in agreement with everything I've heard, okay? Who actually executes that change? Do you as a committee come back to me with what I want to call a re-read line and say, this is what we want?
No, that's not my intention, let's put it that way. I don't think it's our committee's charter.
We don't normally
We come
do that.
back and make our observations.
Okay, so then I would redo that and create that definition.
And accepting or rejecting is your,
Yeah, well, I
Your
accept
option.
that. I just, when I go to the board, because what I'm gonna tell them is, here are your suggestions, okay, that you made to me. Actually, I'll attach, in the board package, the suggestions, and say, here's the changes that I've made to comply. Okay?
yeah,
I mean, I have no problem at all with that. But one of the things just that I've had in going through this is, I basically lifted some things from other resolutions where there are questions.
Mhm.
And where we have conflicts and everything like that. As a board person, I would look to the committee to point those out to me so that I could at least clean it up in what I'm doing.
that's part of our
Yeah,
look for conflict, whether it's the bylaws, other resolutions of DRs.
Yeah.
And to the extent that we may be knowledgeable, HOA Act or other code provisions.
In fact, that's one of the reasons we put that procedure together to get it out, because there is a real misunderstanding of what the committee's responsibility really is.
One of the things we don't want to be doing is the typing, if I can put it that way.
no, I completely understand. I haven't got this, it's a pain in the rear end. I must say a different word, my wife gets really upset. Okay,
And doing red lines is, computers aren't very friendly.
but no, I completely understand. I mean, okay, thank you.
Okay, any more on definitions before I open my mouth again?
No, I think,
Okay, I'm gonna go up to 5A, the definition of OPA member. Maybe a little bit nitpicky, but there are definitions, effective definitions in the DRs, the charter, the bylaws, and we don't need another one in a resolution. The DRs simply refer to membership in the context of being a owner or title owner of a real property within the association. The charter and the bylaws, and I'll read the bylaws provision, add on to that the right to vote. And what I'm getting around to is I don't want us to put in another, would like for us to not put in another definition where we has access to member rights and responsibilities. Yeah, and I know voting is a right, but at any rate, the bylaws member definition says member refers to the owner of a residential lot, condominium unit, single-family attached dwelling, or other real property in the subdivision as specified in the DRs or the charter. It goes on to say that association member doesn't it doesn't have the right, I'm sorry, it goes, which confers voting privileges on the owner. Then it goes on to say association members are not members, they're just associates. I would prefer that we stick to that kind of a definition. I don't know that we need to put in there this litany of residential lot, condominium units, single, family, attached, etc. And just focus on owner of real property with the right to vote, so that we don't have multiple definitions above and beyond what we already have in the governing
agree with
documents.
Would it be appropriate in this document, where applicable, that we said as defined in the bylaws and just left it at that?
But that would, yeah, I don't have any problem with that either.
Then
I just don't want to,
If,
tell me
if,
the
the
wording, tell me the wording you want to see and I'll put it in there.
if the definition is already in there for
In
something that
bylaws.
we're talking about, we shouldn't redefine it.
okay, I'll,
I agree with that.
how
You
about,
have to do one of two things. You either have to refer to it, in which case it stands by itself, or you have to copy it
Yeah.
over ruthlessly accurate.
But then that creates a workload in the future if you want to do any tweaking to the
It does, you
document.
now have two, you gotta update. But you can do either. Sometimes the reference somewhere else is no big deal. Sometimes it's a real pain in the rear end. And to get any kind of sensible look at something, you really need to incorporate the thing in there. We should do that as little as possible, but if we do it, it's a ruthlessly the same definition, even if it has grammar mistakes. Okay, you
Yeah.
include the grammar mistakes, and all of that sort of stuff. It needs to be the same. The easiest one is incorporation by reference. And as long as that's reasonably convenient, it works fine.
Or it's a relatively well understood term that
No.
if it's well, like OPA membership, as opposed to, I don't know, maybe some other term that's more obscure that's not as well known. But I agree with what you said.
okay,
Okay.
what I'll do is I'll add or change the words as necessary. An OPA member is defined in the governing documents.
Correct.
And there is a definition of what a governing document is. Hopefully I don't have to repeat that, but you have to refer to the governing documents to know what a member is. That's not what I'll put down, but that will be the intent.
Yeah.
That you go to the governing documents.
I'm 100% on board and I can give you 845 reasons why.
And the three governing documents I mentioned are consistent. The only difference is that the DRs don't mention voting. They just mention what makes you a member. And the other two documents, the member voting is where it's covered. The voting is covered in the other two documents.
So you pick the best, in that circumstance, you pick the best definition that fits your needs, and you let the fact that it's a different definition at another time be somebody else's argument. Okay?
Well, let's not prolong this. The difference is that you can have a DR standing alone and in an unincorporated homeowners association. Well, we're incorporated, so it's
Yeah.
covered in the charter and then
Yeah.
it flows down to the bylaws. Anyhow, let me not detract from where we're trying to get to. Hang on a second here. That was 5B. I'm gonna skip over that. I have some difficulties with the definition. I've already mentioned that I think may should be in the definition of complaint. But I have difficulties with what we got here in violation. Violation is a violation from an OPA member or non-ownership entity. To me, a violation is a confirmed complaint. Or in other words, it's a complaint that has been confirmed to not be a non-compliance with the DRs or the ARC guidelines. I think we need to define a violation in that context.
It's not just because I pick up the phone and register a complaint. It has to go through that process to be classified as a violation.
And to be frank with you, I don't understand what's being said is a violation from an OPA member or non-ownership entity, other than if it's a complaint, the same thing as a complaint.
Yeah.
I agree.
So
And a complaint, when it's first made, no one knows if it's valid. You don't know if it's any good or not.
Right, yeah.
You haven't done any work.
Yeah, I think that needs to be rewritten, the definition of violation.
Whatever works, I'm 100% in favor, whatever
Okay, well,
committee agrees.
I'll just put in, should be defined as a, what kind, can't think of any other than confirmed.
Validated.
Valid, let's stay away from that.
Yeah.
For this
That's a
meeting.
poison word.
That's a later meeting.
Yeah.
Confirmed non-compliance with the DRs or
Right.
ARC guidelines. Okay, one way or another.
Whatever wording works. By the way, just to be honest and 100% on the record, apparently Cheryl Jacobs and Tom Terry worked for a long period of time when they were on the board to revise M01.
Yeah, they do.
Okay? And what I did is basically cut and paste a lot of work that they had done previously because John had forwarded it to me after talking with Tom. So, a lot of the hard work really is what they've done. And I think the cleaning up of the definitions is something that is absolutely necessary, okay? Just given that I'd be less than honest, we have people telling us they're gonna fight us in court, okay?
That's the 1%
That's
group.
cheap.
Huh?
Yeah,
All right.
yeah, that's right, chalk talk is cheap, but if they do it, Jeff, it's like I told the board, if they do it, and really fight us tooth and nails, we wanna have our I's dotted and T's crossed.
Yes.
Why would somebody spend more money in court to fight something than it costs to fix it?
Because they can.
Some people are stubborn.
Yeah.
Okay, I'm ready to move on.
Okay.
On the definitions, on to 6, we already commented, there's that sentence at the top of the next page, 6B or whatever it may be, if we can.
It's paragraph, it's the second half of paragraph 6B.
Yeah, where it says entering and onto should be when entering. Mark that down, that's editing it.
Well, entering onto a for such. There's still a word missing. Entering onto a property?
It has to be
you're right.
property.
When entering onto a
Has to be a property.
property
Such property, probably.
for such an evaluation, that's,
Yeah.
yeah.
Such property would.
I'd put property. Okay, moving right along, I've said all I have to say about 6C.
Okay.
I need to make a comment or two, write down what, so I don't forget it. We noted this 7 instead of 8. I have a comment about I have a comment about reporting. And my comment is maybe more reporting. I would like to suggest that somewhere in there be some, and again, frequency is not, I'm not commenting on frequency. Every month, every quarter, every year would be a little too long in my opinion, but Colby has, in recent board meetings, I believe, made a mention of the number of complaints that have been entered or maybe taken, maybe I should say taken to violation status, how many in the month have occurred, and how many have been resolved, and X number left over, of course, are not yet resolved. In my memory, that's the first time management has made any comment like that at a board meeting. And I think that kind of information, again, about frequency, detail, all that sort of thing is not what I'm trying to suggest. But I think the concern, the major concern, continuing concern within the membership that I think you get as much or more interest in, I'm sure, assessments and other areas, referendums, whatever, get their interest, but consistently, interest within the association merits some additional information beyond what's being contemplated now. And I'll take that one step further. Not every meeting, but many meetings, something goes to the attorney. I've yet to hear anything come back.
So neither
It
has
doesn't.
ARC nor CPI department ever heard anything coming back. That's one of their number one complaints.
Yeah,
So
okay,
I'm 100% open to whatever, to increasing the reporting of complaints.
There's a natural frequency to these things that'll show up about 6 months in, or maybe a little bit longer. What you'll find is if you start out, pick a number quarterly. If you're starting to get certain kinds of questions, if you're not current on the information when somebody asks, the frequency of your reporting is probably wrong. And I would bet there is no universal frequency for Ocean Pines. Not everything should be reported on the same basis. And there will be things for which annual reporting is perfect, and other things for which quarterly is perfect. In a rare case, you could get down to monthly. I don't think there are very many of those. And I know she's aware, she and I have been talking about that. And I know she's aware of looking at the frequency of the reporting, the various reportings. It's gonna take a few months to figure out what that is. It's not something that's obvious. If you start with the notion that it's all quarterly, you're wrong. It's just how long is it gonna take you to figure that out? But there is a natural frequency to these things. And I don't think any of those are less than a monthly basis. And there are very few that are longer than a year, I would think, but there probably are one or two that are that long.
I agree with your premise.
Okay,
But there-
I would agree. I
would
would
make-
made a note here to do that.
I would put in a suggestion in so many words, consideration of CPI level reporting and resolution of violations, and without regard to periodic
Of violations or of reported
Complaints.
Here's what I have done, guys.
complaints?
Monthly, complaints resolved, sent for court order, cost.
Yeah.
And if you guys wanna put that in your notes, you can say, I agreed to put that in, okay? Josh has it on tape, because I might forget about it. If I don't, and I don't wanna forget about it.
Okay,
We're getting a lot of good play
I have something slightly
out
different.
of the increased reporting that's
Yes.
being done.
Yes.
I think it's good. I think it's helpful, and even more importantly, people are interested in it. Doesn't matter whether they should be or could be, they are. And I think we're doing a good job with the increasing reporting of some of these things, and people like that. And I think it's good.
So I just want to back up just a little bit, because while you were talking about that, I reread a section in here now that I don't know, maybe needs to be tweaked. So if we go back to C, member notification,
Yeah, okay.
that's 6C. If the ARC determines the violation should be pursued. So before you were talking about how most of the issues get resolved, 90% of the issues get resolved in the first 30 days. They get resolved informally.
Right.
The people are notified, they didn't know, they take care of it, it's a done deal. Right? So in my mind, that means this clock starts at some point after that informal period is attempted. You always start out informal, right? You call the member, you talk to them, you try to work it out, right? So in my mind, what I think this means is ARC determines a violation should be pursued. Formally pursued means the informal process has not worked. So does that mean the clock starts here for the 30 days?
Good
Let
point.
me tell you what the intent is. The intent is the clock starts the minute that the person's notified of the violation. Okay? Because as I understand our normal.
Formally or informally?
Formally, for CPI, which they're told somewhere in here in the procedure that if they come on your property and they see a violation, the day after that, they send you a letter. Okay? That starts the formal clock.
So then we go down here to the letter, so that's the CPI first letter that's in step 1?
Right. Now, the reason that it says if ARC determines the violation should be pursued, ARC meets, this is what they would tell you, I believe, speaking for Lisa, which I'm totally not authorized to do. Okay, that they meet twice in the 30-day period, twice a month. Okay? If you come to an ARC meeting, for example, and your fence is, because the surveyor had a bad night at the yacht club or something, 3 inches too high, they can in fact, that is a violation, okay? They can in fact give you a variance. So that would kill that violation right there and it wouldn't be pursued. So they're the determination at that meeting. Now, you may not show up at either meeting, which means it would be pursued. You may show up and you may talk about getting a variance and they may not grant it, or they may grant it, or you may show, I think it's conceivable, okay, but not within anything that I'm trying to do here, that you could show up and say, yeah, it's a violation, and they could say, yeah, it's a violation, but it's okay. I mean, so once they sign off on that, they say, it's dead. But if they don't do that, or you don't show up, the clock is running back to that 30 days, that first complaint date. And then you have until that 30-day window to show compliance by either, if you're going to do work with an outside contractor, showing an example was a signed contract, or if you're going to do it yourself or having a work plan that they agree to.
So that's what got me thinking about this, was reading step 1, CPI first letter. Because in there, we basically say, you've been notified, and then these are steps that you need to take in order to resolve this. But as I'm reading this, I'm remembering what you said about how in the first 30 days, the majority of these issues are resolved. It sounded to me that they're resolved sort of informally. People didn't even know that they had a violation. They just take care of it. So I guess my point was, all these things that we say in this letter, you're going to have to sign contract between the homeowner and the licensed contractor, estimate of dollars for resolving it. Do we really want to levy all these things on somebody who's just going to say, oops, my bad, and go fix it the next day?
No, I think what would actually happen if you talk with the CPI group is that it would never get to the point of them sending the first letter.
Okay, so now we come full circle to what I was saying before.
Right.
If up here we have language that says, when ARC determines should be pursued, a letter should go out. And then down in here we say step 1, CPI letter. So is the pre-step 1 process that we're talking about here? We're not gonna talk about it in here because it's sort of a natural thing that occurs, and it's assuming that step 1 occurs after that fails, or do we need to mention it? Do we need to somehow document in here that there was actually a step 0 that occurred
Mhm.
where people were just talking to you.
I understand exactly what you're saying,
And then
yes.
the clock starts ticking upon mailing the letter.
Yeah, because we don't want to put something in writing that says the minute we get a complaint on John Doe, we're going to send them this letter with all this language about what they got to do about it. Seems like somebody should just pick up the phone and call them. And
I think the first way to correct that is if the ARC determines that the violation exists.
oh, in the first paragraph,
Yeah,
I think that's better.
okay.
Yes, I agree with that.
A letter outlining why should be sent to certified mail, informing the member that the
Yeah.
violation exists, okay?
We're talking about paragraph C, right?
Right,
Yes.
exists, and period, okay? Okay, it exists, so it exists now, okay? Substantial progress towards correcting the violation must have to be worded, but here's the kind of thinking. The violation has been recorded day 1. ARC meets on day 15, okay? They say the violation exists or not by not doing some of the things they can do to eliminate it. The wording then after that word exists needs to be changed to say that 30-day clock started with the date that the violation was noted. Now that puts us at a little risk because what's happening, if you look at it in terms of a time frame, today the violation is noted, okay?
You don't want to use noted.
The violation, whatever they do, the violation is
Acknowledged.
reported, okay?
You want to trigger the date the violation was sent. You want some action, you don't want noted.
No, I'm with you on the trigger. I just,
The violation would maybe clean up the whole thing because somebody are taken care of over informally. The date that the letter is sent starts the
Right.
trigger,
When it's put in the
Yeah.
mailbox.
Yeah.
I agree with that.
okay?
I agree with
That'll
that.
do it.
But when is the letter sent? Is it sent after the informal fails?
No, they have, if they go and they say, look, hopefully this is how they'll execute the thing. I mean, it's kind of telling somebody how to do their job, which is probably not the right thing to do. But so somebody complains that your lot has grass that's head high on it. So the CPI inspector goes there and some way makes contact with you, phone, talking with you in
Right.
person, and says, look, you gotta chop this baby down to your ankles, or, this is a violation,
Right.
okay? And the person says, okay, I'll do it, I'll get it done tomorrow, or I'll get it done today. Okay, we're square, and CPI either feels they're gonna do it, or they come back the next day and they check. Or they don't, they say, hey, look, this isn't a violation, okay? So they send it the next day, and that's the trigger date, okay? And that starts the 30-day clock.
I think that's
For
a good
everything.
idea.
Yes.
Yeah.
Now, Frank, when there are variances given
Mhm.
to homeowners for some kind of infraction, where is it recorded that that variance was granted?
I'm going to tell you, not being intimately involved with the committees, both with the ARC and with the CPI Department in Public Works. But I don't know exactly what that paper
Okay.
trail looks like. But I know they do give variances.
Well, yeah, and we've had it in our neighborhood a couple of times where variances were granted for building a foot onto the wetlands behind our houses. And new owners have come in and it's been a nightmare for them.
Yeah.
Well, see, that brings up a question. Does it carry on to the new owner?
Well, if a variance,
Because some
Yeah.
variances are for, I could see some variances being granted for an existing owner. Maybe it's an elderly couple, maybe they're retired, maybe there's limited funds. The violation is not significant. But typically when you sell a home, the idea is that it's brought up to code or the new owners are expected to bring things, into compliance. But that all just comes full circle around to your question of where's this stuff documented?
right,
And to what applicability is it documented?
Plus, in Cammy's case, I would be kind of a little suspicious building on the wetlands. I wouldn't be concerned about
Yeah,
OP coming. I'd be a little bit concerned about EPA coming and talking.
Oh, yeah, then there's that.
Right.
Maybe a couple more years.
I'm gonna tell you, you don't wanna mess
To kind of
with
try to
it.
summarize this last comment, what we're talking about is in 6C, clarify the process or timing of when the 30-day
Yeah,
30-day starts.
Yeah, when the trigger.
So,
Usually when you send something, that's a great trigger because there's a physical act that occurs that can be documented.
But if we don't, so nowhere in here do we talk about step 0,
No.
which is the informal. So if you didn't know that, you weren't sitting in this room and you're just reading this document, you would think step 1 is step 0. Meaning the minute I get something and it's verified, I'm sending you a letter, we're gonna start the whole process. I'm not gonna pick up the phone and call you, I'm not gonna tell you to cut your grass, and have it done tomorrow. I'm gonna send you a letter, I'm gonna require you to get an estimate, all of these things. That was my point,
It's got
so.
a more hard-nosed feel to it, certainly.
Well, and to what you've said this a number of times in here, that we have to be careful with this language, because there's always somebody who will attempt to use this language in a way it was not intended
That's right.
by the author, that will have repercussions that we'll be dealing with later.
Happens all the time.
So I guess my basic point was, should we talk about step 0 in here somewhere?
the note to myself is step 0 equals the violation, step 1 equals the letter, and then I have step paragraph, which means break this thing
I think
down into
that's good.
steps.
Yes.
Okay, would you, if you acknowledge that to me in your notes, because I will keep this, but Lord knows, it could get lost between here and my trip down to the. I mean, let's be honest with each other,
Could get lost between here and the door.
I skipped over a comment that fits a little bit into what we're talking about here, this most recent one. We have 2 addendums, A and B, but they're nowhere mentioned in the text. And to a certain extent, we're talking about referring to in that 30-day start, that there's a reference to when you start addendum A. And then referring to B would be what goes to from ARC to the general manager after that 30-day period, nothing's been done. I think it would, again, this is drafting technique. I think if you got something you're gonna use in the resolution, there's some actual action being taken, refer to the source of how you do that action. In the case of the process of getting to the GM, you've got the steps in the addendum A, and then the GM receives what's in addendum B.
Right, so you're saying,
All right, I'm ready to go. I was talking about addendums A and B. I'm ready to go to addendum A if nobody has any other further comment before we get there.
I'm gonna have to leave this for a minute.
Okay. My comment on between step 2 and 3, we at 15 days, we go out and check again to see if the violation still exists. Is there any further inspection, or we just leave it up to the staff to verify before the GM gets cranked up to go to court, so to speak?
As long as we make them aware that it's pretty important, because he's gonna look like a fool.
Well, no, I think the point is, this says after 30 days. And we've all been talking about 30 day being the trigger, right? So shouldn't there be a step 2.5 is the 30-day trigger where you confirm the inspection or whatever, that it wasn't done, and then the step 3, the ARC letter, blah, blah, blah.
I agree with that.
There's no confirmation
We
that,
need a finite time under which the property is re-inspected to note that the violation still exists and there's been no progress in
Right.
correcting the violation.
there's an interim, which is the 15 day,
Yeah.
but there's no final.
Right.
Yeah.
what I would, how about if we just do this, supposing we do a 30-day inspection,
Yes. To
okay,
confirm.
follow up 30 days, and kind of say, And I want to think what else would have to be changed in here, and I can't think of anything right off the bat, but maybe something.
Frank, how would you deal with the situation where somebody has a contractor and the contractor got into trouble and didn't get out within the 30 days
Well, that
to
never
make the
happens here.
repairs?
Well,
That
here's-
never happens here.
That'll never happen.
here's
How
kind of
do you deal with it?
what I call my common sense approach to it.
Okay,
Okay, let me give you two scenarios that I have at least in my mind. Scenario A is, especially if you just go 30 days and take what I call the grown-up approach and say, you have 30 days to do it or show substantial progress. In 30 days, we're gonna come out.
Right.
So somebody says, well, and this happened to me, so I give you a case. I just moved in, okay, or I'm here, I tried to get an electrical contractor, which did happen to me. And it was June, and the electrical contractor that was given to be very reliable came out and he looked at everything and he said, I can give you an estimate and everything like that, and I can be here September 15th at 1:30 in the afternoon.
Mhm.
Okay? So that's step one, and he gives me an estimate, and I sign that estimate, okay, contract. And I have a contract with him. So CPI comes, and there's a violation, and you say, have you shown substantial progress? And you say, yeah, I have a contract. My electrician happens to be JT. Okay, I have a contract with JT. It's signed here. Here's the estimate he signed. I signed it. He's going to be here September 15th. Okay. Now, common sense would say if that's in the summertime here, that's probably not an ideal situation for the neighbors, but you've gone to a reputable contractor. You've gotten an estimate. You've gotten a contract. You've signed it. He's signed it and it has a price on it.
Yeah.
Okay. Boom. Substantial Okay. So I go to the same scenario B. I go to a person and they say, yeah, I've been calling contractors. Sure, let me get out my sticky notes and I'll show you. But, none of them have called back or three of them haven't called back. That's not substantial progress.
Right.
Okay. And, I understand everything with contracting around here in the Eastern Shore, but I also understand that if you really want something done, you can get a signed contract to do something within 30 days. Maybe not the work done, but you can get a signed contract to do it. Okay.
I agree with that. So this step that we're talking about inserting in here,
Mhm.
I think that should be the language. Has it been resolved or are they under contract to have
Right.
it resolved?
And that's what I do
Yeah.
when I
Well,
take that.
That's the marker.
Right, right.
That's this thing right here. When you do paragraph C, step that's the show substantial completion. There is one sentence we haven't discussed, okay, in there, unless it's a repeat violation. If it's a repeat violator, these guys that have a tendency to have cars disappear and reappear, the GM is authorized to go immediately, okay? 2 days, not 30 days.
Right.
Okay. So by just not making it a 30-day inspection, then they've had their what I call due process, and that's the whole thing I'm concerned about is, we've noted a violation, you've had a chance to go to ARC, they've had a chance to give you a variance, you've had a chance to show substantial completion, or if you do it yourselfer, okay, you have a project plan. I mean, and if it's moving a fence, people should put together a project plan that makes sense.
Sure.
And it may be written in many different ways, okay?
Sure.
But it either makes sense or it doesn't. And it has to have steps that the CPI department can come and check and be enforced.
Sorry, we have a 3:00 meeting scheduled as well. In here.
I'm not sure.
Sorry, normally we do 2 hour for committees, so
All right, can I have 60 seconds more?
I will tell them you'll be out
All right,
momentarily.
'cause Frank, Kevin and Frank and everybody else, I want to briefly mention M04, very briefly. I don't have any problem with the deletion, red line part about it, but there was a change going from older resolutions to M04, and it was mistakenly handled, in my opinion. The two prior resolutions, one was simply for debris. The other was simply for tall weeds and grass. Each of those resolutions, I've got copies of them here. I can hand them out to you, but each of those resolutions specifically refer to the OPA maintenance provision in the DRs of the 2/3 majority authorization.
Right.
Not having that in M04 was a mistake
Okay.
and should be rectified if we're going to continue with an M04. It specifically refers to meetings in which the vote was such and such, meaning 2/3 majority, and this is direction to the general manager to go forth and use it in these cases. Now, one again was debris, that's being done away with. The other is grass, weeds, whatever. That is a proposed amendment. That needs to be rectified in that resolution.
Let me let me have 15 seconds. The overwhelming, and I think I don't think I'm speaking out of school. The GM, police department, CPI, public works, and the attorneys do not want to be in a position where the board authorizes somebody to go on the property and do anything. We want to go right to the court order. So whatever way we can expediently correct the issue that you brought up within that context. And it sounds to me like the police particularly, public service and public works don't want to go on a property for any reason without a court order.
Well, then the M04 should be canceled.
Then if you come back with me in your email, when I present it to the board, I will also make a motion then to rescind M04.
Okay, that's,
Yes.
we'll go forward with that.
Yeah, that is not the kind of thing that just should be canceled by omission. You know, you cancel the whole resolution.
Let's dot our i's and cross our t's. I agree with it.
I don't have any further comments on, we didn't cover C02, that's the ARC resolution. We did comment on this clarification of authority, where that has, whatever the wording was, as appropriate, and that sort of thing. But let me say this, I'm gonna put together some remarks, comments, be circulated amongst the committee. I'm not gonna worry about open meeting violations or anything like that. Get that out, make sure everybody's in agreement with what we're going forward with, and get it back to the board and Frank as soon as possible.
We may have to go through another iterative process on it. And that's okay. You know, I prefer not to delay and prefer to have it this board meeting, but I also want to do it right. And the second thing is, right now, I think that the board is of a mindset that when we find these folks, to authorize the GM to go to the court order anyway.
Well, I have to agree.
So,
I'm gonna deem us adjourned at 3:05 or something like that.
thank you.